Depositions are a discovery tool used by lawyers to find out what they do not know about a case and to obtain a sworn statement from a witness about what they do know. Depositions are typically conducted in a court reporter's office, with the parties and their attorneys being in attendance. The parties or other witness is put under oath, and then they can be asked questions by the attorneys about the facts of the case and their knowledge of the case. The court reporter records verbatim the questions and answers as they occur, and eventually a transcript, a written record of the deposition, will be prepared by the court reporter for the attorneys to use at trial. In many instances, both the parties are deposed on the same day. In other cases, experts who've been retained by the various parties may be used in areas of children's issues or financial issues, and they can also be deposed. Various exhibits may be brought into the deposition, and witnesses or other parties may be asked to testify about the exhibit and its contents. The nature of the questions that can be asked during deposition are very broad in nature. Anything which might lead to possibly admissible evidence is permitted. Many parties find the process of undergoing such a deposition as being somewhat nerve-wracking, but a simple change in reference can usually help our clients overcome their anxiety about the deposition. First of all, remember that there is no right or wrong answer. Attorneys are merely asking you the questions to get your answer, and as long as you testify truthfully, then your answer is not right or wrong. So just answer the questions truthfully, and everything will be fine from there. Now, all that being said, it's important to know that your testimony at deposition is still very important. It is a sworn statement about your position in the case. Your responsibility is to listen to the question completely before you answer it, and to then answer it truthfully and completely. Do not ever try to answer a question when you do not fully understand what's being asked of you. If you don't understand the question, ask the attorney who asked it to clarify the question until you do understand it, and then answer only that question and stop. You do not want to volunteer information that goes beyond the question that was asked. You should also not allow an attorney to bait you into saying more than you intended by remaining silent after your answer. Be comfortable with the silence, and once you've answered the question, you make the attorney be the next one to speak. Here's some other important points to remember that will help make the deposition process easier for you. If you're asked a question about a document, such as a financial affidavit or a police report, you are entitled to see that document before you answer the question. And remember, don't get angry or try to sell opposing counsel on the merits of your case. You won't convince them that you're right, and you may actually hurt your case by providing too much information. Finally, be clear and consistent about the facts you testify about. Your deposition will be used at trial to confirm your testimony has not changed in some respect with regards to the facts of the case. The very best result an opposing attorney can hope for in a deposition is that he gets information from you that will allow him to prove to the judge that you were not truthful with your answers. That is a situation that you must always avoid. So remember, tell the truth and nothing but the truth. At the Law Firm for Family Law, we meet with each client prior to deposition to ensure that they are comfortable with and that they understand the procedures involved. Because we do not take every client that calls us. We do not charge our clients for their initial consultation. Call us today and see if we can be of assistance to you in your case, and please call our office to schedule a consultation.